The Deputy Head of the Presidential Administration, Mr. Oleksiy Filatov, who's responsible for judicial reform. Thank you.
Доброго дня.
Good afternoon. I would like to share some news and information on the developments with the process of judicial reform in Ukraine. As you know, the Verkhovna Rada voted in the first reading for two draft laws. The draft law developed by the Council on Judicial Reform and number 1656 and draft law number 1497 drafted by the group of the MPs on judicial reform. The Verkhovna Rada made a decision that on the basis of the Committee of the Verkhovna Rada on Law Policy, the working group is to be set up, which will work on the coordinated version of the draft law, which will be submitted to the Parliament for the second reading. Yesterday, the committee had a meeting, and the decision was made to take the draft law 1656 as the basis to develop amendments and proposals, considering all those that were submitted by the MPs and other subjects of legislative initiative, and create the working group involving the experts who submitted their proposals to participate in this working group this way till next Wednesday, to come up with the proposals which will be considered to be included into the draft law 1656. A similar opinion was developed at the meeting of the National Council on Reforms, which was held on Monday, where the heads of all parliamentary factions were present. The agreement was reached that the draft law 1656 will be used as the basis to develop the agreed-on draft law so that it is approved in the second reading. A few words on the content of the draft law and on what is being suggested, what is now the Parliament considering, and what will be discussed at the working group meeting in the Committee on Law Policy. It's about the first step on the way to judicial reform, and that relates to issues on ensuring independence of judges, the procedure of selecting judges, the procedure of development of judges' career, and making judges disciplinarily responsible if they violate their duties or the oath. Now there are different opinions, and some politicians sometimes use the issue of judicial reform to express their opinion, which is normal in democratic society. Secondly, to receive certain political dividends, which is easier to earn when you criticize some provisions of the draft law which are submitted to the Parliament. There is an opinion, for example, that the draft law submitted by the President provides for strengthening the powers of the President and strengthening the influence of the President on the judges. That is not so. Any specialist who really read the text of the draft law, who looked at the comparative table and compared the existing law on judiciary and other regulations into which the amendments are introduced by the draft law, can make conclusion that the powers of the president will be reduced, the same way as the powers of the parliament will be reduced and limited. This process is going on simultaneously to provide to the judicial system more independence. How is that happening? I will give you an example. If today, for example, transfer of the judge from one court to another requires the application from this judge and the certificate from the highest qualification commission of the judges, and if this judge who was elected for the first 5 years, the president at his discretion makes a decision about transfer of this judge from one court to another. If the judge is elected for life, then the Verkhovna Rada is doing it without any objective procedures or criteria. The draft law that we suggest for preparation to the second reading provides for any position in any court, irrespective of whether it is about the appointment of the judge for the first time or whether the judge should be transferred from one court to another. Any position is held only on the grounds of the competition. The competition is open, public. Neither the president nor Verkhovna Rada have nothing to do with this competition. At this competition, the main for the candidate is to demonstrate whether he satisfies all the professional requirements and moral and ethical criteria according to anti-corruption legislation. The High Qualification Commission, which is the body where the majority of members are elected by judges themselves, and the members are elected according to the proposal which is submitted to the parliament by the Congress of the Lawyers, the Congress of the Representatives of the Universities, and this way we ensure the control of the public over the procedure of electing the judges and appointing to the position. After the High Qualification Commission passes the decision, this decision cannot be changed. The Verkhovna Rada of the President can only implement that decision. And this way, any interference of both the Parliament and the President and any political influence on making decision on the judge taking a position in a certain court will be eliminated. Other mechanisms which prevent the influence and which are suggested in draft 1656 are the highest qualification commission and the highest council of justice, and they are responsible for decisions on judges' career. They are selected according to the transparent procedure, and the public can control that procedure. How is that happening? Any candidate to the member of the Council of Justice has to be known. There's a time frame set for publishing the data about this candidate. This candidate provides a big amount of information about his professional activities, about his property status. It's about excluding any potential candidates which do not satisfy the requirements of anti-corruption legislation. This information is open. Any citizen can see it, or any delegate to the Congress which elects the members to both entities. Besides, the prohibition is for taking two positions, which is not now in the legislation. The draft law 1656 provides for the member of the highest Council of Justice cannot be the position in the council, or the member of parliament, or the civil servant, or having a position anywhere else, with the exception of in the educational institution. So this way, any potential conflict of interest will be avoided, and the conflict of interest may take place when the civil servant gets some decision of the court which he doesn't like, and then he considers the case on the judge who passed that resolution. We understand that the time frame that we have and the requirements which exist in this society as to ensuring the right of the citizens for just court require a lot of work. Next week we are planning to work every day in such a way that we develop the amendments which would be approved in the working group, and also we will prepare it for the second reading. I'm ready to answer the questions.
Mr. Filatov, here's the question. Maybe it's not about legislation, and I hope that will be approved in the nearest future. It's about practice. It's famous. We know that a lot of judges who have they have evidence that people involved in separatism or corruption, they don't sentence them, and then they disappear also. How realistic? How realistic it is that those judges will stand the trial? That's what the society is demanding. In this sense, there are two aspects. The legislation allows law enforcement bodies to do their job well. If that doesn't happen, it's not an issue to legislation, but to concrete law enforcement bodies which don't react to crimes or abuse. And the legislation can be improved. The legislation 1656 includes that. And speaking about the responsibility of judges, the draft law says proposals that will not allow to take judges to responsibility just because some public officials don't like their decisions, but we make a concrete list of sanctions applied to judges who abuse. If now, according to the law, there are only two sanctions, and it's a rebuke, and also it's a very relative sanction. And there is nothing negative about dismissal. It's a sanction, which is the highest. The level of and gravity of the abuse a judge has to take is quite high. The draft law, which we suggest to consider, provides sanctions like from 1 to 6 months that person will not be allowed to practice, and to send to retrain, and could be sent to a different court or some other sanctions that are more efficient system than we have in our law. Any question? Oleksiy, thank you very much for the tender explanations, and thank you very much. Next briefing in 10 minutes.